Oak Sparrow Properties and Sandy Property Management versus Chase Carson and Amanda Williams. What's your name?
Chase Carson, Your Honor.
What's your name?
Amanda Williams.
Council appearance.
Good afternoon, Your Honor. Jessica Larson on behalf of Plaintiff Oak Sparrow, along with representative of the property.
Okay, today was the date set for hearing. This is for termination of tenancy. Did the parties come to a resolution?
We haven't spoken on this one, Your Honor. From the prior hearing, my understanding is we've got quite a dispute. I don't think that we're in dispute on possession. The tenants are indicating that they actually vacated far before we believe that they did. So I don't know. I don't think that a resolution is likely on this one, Your Honor. I do say that I will say the issue of possession is probably moot because the tenants are indicating you moved out.
I don't know what prior hearing you're talking about. I have a note here. Let's see. It's a breach trial. Present. Then it's no longer in possession of property. There was a hearing for the 18th. Okay, so what happened? You're saying you vacated the property?
Yes, Your Honor. I was served a 7-day on May 24th. I'm new to this whole process. I've always paid all my bills. So at that point, I uprooted everything that I could take, including my family, and we vacated the property. I attempted to make a phone call to Miss Sandy Bristol, fell upon deaf ears, as many communications had to that point. At that point, thought this was all behind us, and then all of a
communication
sudden,
saying that you have vacated. Is that what you mean?
yes, I attempted to contact her and let her know the key was on the counter, and we were out of there. No response.
You have record of where you.
I did text her and ask her why on the day of the that I received the 7-day, because at that point it was to my knowledge we were doing everything that we could to stay in the property, because we had previously had a case due over our animal that they tried to evict us and they lost in court. But for whatever reason, that still shows up on our record. So when we attempted to go get a new home when they refused to renew our lease, we have a red flag. I can't rent anything. They won't even show me places. So I reached out to Miss Bristol, and in good faith, I said, I will do whatever it is in my power to keep my family in this home. I jumped through their hoops. I gave them record of my dogs. I obtained insurance.
I'm talking about this eviction though?
What's that?
I'm talking about this eviction, not the previous one.
Yes.
Okay.
Yes. So, I'm sorry. I guess I misunderstood.
Okay, because I thought you were talking about there was another eviction.
There was an attempt at it. They were ruled against in the courtroom.
So since receiving this notice of eviction, that's when you reached out and said you would do anything?
Yes, after when I attempted to, because then we went back and finished out our lease, and then we got a letter in the mail that they are choosing not to renew. So I was like, that makes sense. And I attempted to find a place. When I realized we were blacklisted and I couldn't even rent a place, then I reached out to them and said, I'm willing to do anything that you would like. And I did everything they like. They walked the property. Everything looked good. There was no damage to the property. And then all of a sudden the letter comes in the mail, you need to leave within 7 days. So in fear of another thing going on my record, I took what we could and we vacated there. We were gone before June.
When you say you took what you could, doesn't sound like you took all your stuff.
No, ma'am. No, ma'am.
Then you didn't turn over possession.
Like I said,
What did you leave there?
I just things that we didn't have space to store or anything. I took the possessions, our day-to-day possessions, and we bounced around since. We were going to make an attempt to clean the place up if that was their request, but again, she did not give me any communication back and forth until we got a new court date.
So you communicated with her in via text after you left?
Yes, I asked her on the 24th. I said, why? And she says, you have continued to ignore us. You never submitted the animal application, and the dogs were an issue. It's too much of a liability.
Did you tell her that you vacated? Did you tell her that you vacated?
No, because I hadn't at that point. This was the day that I received the 7 day.
I want to know about you communicating that you vacated.
That was a telephone call.
Okay, you called her?
I don't have a record of the telephone
call.
call.
Did you talk to her on the phone? or did she not answer?
No answer.
Did you leave a voicemail?
I was not able to leave a voicemail.
Why not?
To be honest, I don't know if her mailbox was full or what have you, but I wasn't able to leave her a message at that time.
Okay, so how was she supposed to know that you vacated?
Answer the call.
Okay. So when you called, let's say she was tied up and busy, couldn't answer. Or maybe technology didn't work well, and she didn't even know you called.
I don't know how to answer that for you. It was a confusing, scary time for me. I have not experienced things like this. I just like I put my hands in there. We're out of here. Like I've done everything I can.
And you left the keys there? You
Yes.
stayed at the property? Okay, counsel?
I'm sorry, Your Honor.
Counsel, did the property appear to have been vacated, but there was a number of things left there?
There was a substantial amount of things there left, Your Honor. From my understanding, the tenants continued to reside there because they were paying utilities there. And so the date of the hearing that I think Your Honor read, that was in front of Judge Buchanan. My client didn't get notice of the utility switch over. There was no indication of keys being left. There was no written notification. There was no verbal notification. Up until that hearing, we had no idea that they were going to even claim that they had moved out back in May.
Where were you still paying?
Well, we had past due amounts, so I was paying the minimums at that time to keep my name from getting to the point where I wouldn't be able to put utilities in my room at the next, or I mean my name at the next residence that we would be at.
My client didn't get notification of any utility turnover until, again, after the hearing that was before Judge Buchanan back in November.
Which all would have been communicated had her client answered the phone call, but she put me
Well,
on
you
silent.
You didn't change the utilities over to your new place. Where did you, when you
I
left, where did you
can't find a new place because
Okay,
of
so
this.
you don't have a new place?
No, I'm bouncing around, staying with my mother at the moment.
Okay.
This has created quite a
But
situation. for us.
you didn't disconnect the utilities at the place. You just was paying about. You have some evidence of the utility bill.
No, I don't have evidence of the utility bill.
Yeah. So do you have any evidence of what was left in the property?
I have a ton of videos and photographs, Your Honor. My client has also gone by the property several times and can indicate that the vehicle that Mr. Carson and Ms. Williams, that vehicle was outside of that property on many occasions when she was driven by. There's a ton of stuff outside of the property. There was absolutely no indication that these parties have vacated. There's shoes on the porch.
Show your evidence.
And Your Honor, I will say too that the client.
Was there any physical evidence of us being there, or a picture of my vehicle there? Because I can guarantee that wasn't the case. Then
And
they park
Okay.
in the driveway next door.
Okay.
Well, how would you know where my client parked?
Where are you? If you all want to talk
They
off the
didn't
record,
park
off the record. Bye. You can talk outside if you want to talk to each other. If you want me to handle it, then you talk to me. You can talk outside. Next case. Back on the record, counsel. And this is Oak Sparrow versus Carson and Williams.
Thank you, Your Honor.
And you've not come to resolution, correct?
We have not. It sounds like we're at an impasse, Your Honor.
Okay, so then you need to talk to me and not to each other. Back and forth is not gonna be allowed. If you start back and forth, I gotta move on. Look, all these people behind you waiting for their turn.
Apologies, Your Honor.
Okay, I'll allow you to present your evidence.
At this point, Your Honor, it sounds like based on some of the claims that the tenants are going to make as far as the utilities and how those were paid, I'm not able to access that. My client is not able to access a record that is in the tenant's name without a subpoena. So I'd ask the court to allow me to issue a couple of discovery subpoenas and reset this matter.
You said about how the utilities were paid, you mean?
Yes, my understanding is that utilities remained in the tenant's name, that they were paying those regularly until that November hearing with Judge Buchanan. The tenants are now claiming that they were only making the minimum payments and they were paying the past due amount. I'm unable to access those records. My clients have called and they've tried to get at them, but the utility companies obviously are not going to release an account in someone else's name. So I think that would be an essential piece of evidence in this case. And so I'm asking for the ability to issue subpoenas to Water Right and consumers.
That's fine. Is the property secured and winterized?
My clients have gone into the property, Your Honor. I don't know if they have. I would like an order actually confirming the possession that they can retake it, because they have gotten a notice from the city that they've asked for an extension until Monday in order to remove trash that's from the property. Otherwise, they're going to give a violation.
So there's trash that you're saying that they left. Can I see?
Yes.
Ron, is that something that I'm privy to as well? Pictures of
Okay,
trash?
so it's front porch. This is from the code enforcement. They said that there was trash found in boxes, bags, and barrels on front porch, clothing and cloth products on front porch, deteriorated metal product on front porch, loose trash and debris, front porch, in yard, around and behind the house. Did you leave trash at the property?
I guess you could consider it trash. Yes, there were several items that I explained that I had no choice but to leave behind. I didn't have.
No, you have a choice.
I did not.
You do have a
I had the
choice.
financial ability to do that.
Did you put the trash there?
I'm sorry.
Did you put the trash there?
There were items in the home.
Did you put the items,
interpreting them as
did
trash
you
is
put
not
the
trash.
items, did you put the items that have accumulated causing code compliance to come and issue this concern violation about? Did you put it there?
On the porch? No,
So the things there are not yours? How did they get there?
I don't know. They've had the property.
Do you have
since May.
pictures?
I have some pictures of the exterior of the property, yes, Your Honor.
I can't say what they're.
I didn't ask you to speak right now. Do you have copies for him?
I handed him one.
Okay, I see a helmet, I see a, look like child's car, a welcome mat, or something, welcome thing. I don't know what this is.
Again,
I didn't ask you to speak over me.
Oh, I'm sorry.
It looks like something else on the porch. I don't know what it is.
Looks to be boxes and shoes.
You said boxes and what?
It looks to be 2 empty boxes and a pair of shoes.
What are the toys in the front yard?
Those were toys that my children played with outside that I have nowhere to store now. So they were items that were, yes, and left behind.
Okay, so there's shoes, there's boxes. I do see debris. You didn't put those there?
I'm sorry?
You're saying you didn't put these things there?
That's why I said, is it trash or what are the items so that I can
You,
specifically tell you? Like, I wouldn't consider my kids' toys trash, but to each their own opinion.
you left the things here?
Yes, Your Honor.
That they're supposed to be responsible?
This
for
photo
you?
was taken while we still live there, by the way. That item is in our that football helmet is currently in our possession. I don't know where these pictures were taken or when, but that time frame they just gave you is wrong. Actually, multiple items that are in these pictures are currently in my possession.
Could I ask him to confirm what date he's going to say that he moved out?
What day did you move out of the property?
It would have been May 30th and 31st.
My
That
client
was the
took these
moving.
photographs at the end of June.
Any other evidence that you have today?
I have a witness with me, Your Honor.
You take the stand.
Okay.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat.
Kim, can you state your first and last name and spell your last name for the record?
Jennifer Willcutt, WILLCUTT.
And are you a representative of Oak Sparrow Properties?
I am.
Are you employed by Sandy's Property Management?
I was in 2024, yes.
Thank you. And are you familiar with the file for Chase Carson and Amanda
I
Williams?
am,
Have you, and they've lived at 1317 West Shiawassee Street.
correct.
Have you, since May of 2024, have you been to that property?
Yes,
More than once?
I drove by the property at least once a month from June until November 20th was the last time because I was told that they had told the court they had vacated.
And that's all through 2024.
Yes,
And did you observe any changes in the property between May and November?
yes,
Did items appear to be moved?
yes,
Did it appear to you that there was somebody residing in the home?
yes.
Are you familiar with the vehicle driven by either Chase Carson or Amanda Williams?
I've seen Chase put dog into I think it was a white kind of work type van possibly, or a panel. It was, yes,
So you would recognize their vehicle?
I recognized it on the street, yes. I wouldn't recognize it out in traffic.
Fair enough. When on these occasions that you've described driving by the property, did you observe that vehicle?
Once or twice in the street, yes.
And that was a vehicle that you had seen Mr. Carson access?
Yes.
At any point in time over the summer of 2024, did you get any notification from the city regarding any unkept lawns?
No.
Was that an indication to you that the lawn had been kept appropriate for
Yes.
the city? Sure. I'm sorry? You said something, sir?
Do I need to?
I thought he was interjecting. I'm sorry, Your Honor. Okay. Are you familiar, have you been in contact with the utility company in regards to 1317?
Yes.
And at any point in time, have you received notification that the utilities are being transferred into Oak Sparrow's name?
No.
What is your understanding of the status of the utilities?
On November 20th, 2024, there was no water or electrical service. I called Lansing Board of Water and Light at that time, and they told me that services were turned off on November 18th, 2024. I called Consumers Energy on November 20th, 2024, and they told me the gas service was still in tenant's name as of November 20th, 2024. I later went back to make sure that the property was still secure on December 5th, 2024, at which point there was no gas service. I called Consumers, and they said that it had finally been turned off in tenant's name on December 3rd, 2022.
And you said you appeared at the property on November 20th initially, and then
Yes.
again on December 3rd. Yeah, thank you. How did you gain access to the property on November 20th?
I was told that they had stated that the tenants had stated in court that they had vacated the property, and I was asked by my superior at the time to secure the property. So I asked maintenance to please schedule a time to go over and get the locks open so that we could change locks and secure the property properly. No items were touched or removed.
When you appeared on December 5th, did you notice any differences in the property?
The door was open, and it looked like to be some kind of snacks or something on the stairwell in the living room. Things had been moved around a little bit, and that was about it.
Can you just?
Oh, the garage door was also, we had secured the garage door, and that had been opened up as well, and it was like items that been moved around in the garage.
The photographs that have been presented to the court for the outside of the property, is that fairly representative of how the interior of the property was kept as well?
The interior has a lot more trash and items left out than the exterior.
Oh.
The exterior is not the worst.
Can you give a general description of the interior of the property?
There's a large mirror in the middle of the kitchen. There's trash bags that the mice have now taken over. There were baby and children's toys in the living room. I think some type of small animal bedding, a bag of animal bedding was in the living room. And then there was just general personal property throughout, clothing items, shoes, children's toys.
Were you able to speak with any of the neighbors who live nearby at 1317?
Yes.
And did they give an indication of observing the Mr. Carson and Ms. Williams there?
It's hearsay.
At any point in time, have either Mr. Carson or Ms. Williams indicated to you or to your knowledge, have they said that they were moving out?
No.
In April, did they indicate that they wanted to renew their lease?
Yeah.
Were you working on actively renewing the lease?
We were actively working on a month-to-month agreement.
What's your objection?
That is not the truth.
Objections are for evidentiary foundation, not that you dispute what she's saying. So if you dispute what she's saying, when she's finished, I'll give you an opportunity to give your testimony, but that's not an objection.
Okay.
So you can continue, ma'am.
Thank you. Did Mr. I want to call him the Carsons. Did Mr. Carson or Ms. Williams turn in their keys at any point?
No, not to my knowledge.
Did you ever receive any written notification that they were terminating their lease?
No.
Did you actually appear at the property on May 1st of 2024?
I did.
What was the purpose of that appearance?
To inspect the home to see if there was any animal damage and to give animal applications and to explain what paperwork the owners have requested in order for them to stay in the property with their.
And so that was part of a process of extending the lease.
Correct. Mr. Carson also provided me with documentation for the dog licenses and vet records, which I did copy for him and return on May 7th. I did not enter the property on May 7th.
After May 2nd, did Mr. Carson ever indicate to you anything different other than moving forward as a renewal of the lease?
No.
Are there any other facts or details that you think would be relevant to the court as far as this matter and whether the Carsons moved out in May?
The picture with the football helmet that was brought up, I took that personally, and that was on June 27th. Trash bin was also at the curb. On November 20th, the trash bin was in the backyard by the garage.
Any other details that you recall of items being moved around or?
There's a small child's car, I believe it's green. When the picture on the front, I think, shows it in front of the stairs, that on November 20th, that was moved into the fence area.
And the helmet's missing.
And the helmet was missing.
And then, had the tenants paid any rent between May and November of 2024?
I believe their last payment was May 2024, mid-May.
Do you recall offhand the unpaid balance that's owed to the tenants?
I do.
If I showed you a copy of the ledger, would that refresh your recollection?
Yes, it did.
Go ahead and take a look at that. Don't testify from it, but when you read it, go ahead and look over it. Okay, do you recall the amount that's unpaid rent for the tenants?
$9,900.
Thank you. I don't think I have anything further, Your Honor.
Do you have any questions for this witness?
One sec. So you say that you've gone by once a month at least to check on the property.
Yeah.
And you've seen a vehicle that you believe to be mine there, correct?
A few times, yeah.
And what was that vehicle?
I think it's a white van or some type of panel that has doors on the back.
Your Honor, I have no white van. I do not own a white van.
Okay,
I've never.
this is
owned
time
a
for
van.
you to give or ask her questions, not time for our.
Oh, okay.
Okay.
Sorry. Yeah, that. And are you familiar? You said you were familiar with neighbors then?
I did not say I'm familiar with the neighbors.
Okay. Are you aware that they have children there?
I did not.
Okay. And are you aware that children will play with toys if they see them, such as a power wheel left outside that could move a couple times?
Objection
Because
calls for
kids-
speculation.
Just saying that the neighbors next door, they have several.
The question
children
is
that
it
play with
possible,
toys.
is it possible that the neighbors?
Yeah, is
Yeah.
it possible that someone else?
No, I'm asking you, was that your question?
Yes, Your Honor. I'm asking, is it possible that someone else may have moved a toy outside the home? That's what you're going on
Objections
for us to be
overruled, you
there?
can answer it.
I guess anything's possible.
Okay. And any of the times that you have drove by the home, did you physically see myself or any member of my family? Okay. And when you called to ask about the utilities, they wouldn't speak to you, correct, about how it works? So it's a good possibility that we were paying the minimums to keep our
Objection,
name from
argument.
getting.
Well, That
And
would
that's
cause
speculation.
speculation. That causes speculation. You don't have to answer that.
Okay. Well, my point, Your Honor, is that in order to get something taken out of your name, you have to pay it in full. This came out of nowhere. I had no means to pay it in full. That explains why the utilities were continued to get paid and stayed in our name right up until the point where they just shut them off. It wasn't turned off because we.
I understand you've cleared that with me
Okay.
with the, as part of why you made those payments. They're asking for a continuance so that they can get the records. I'm just getting their testimony now, so when we come back, we don't have to do that.
Understand.
Do you have questions? Any more questions?
Not for her, no.
Okay, thank you. Any redirect?
Why do you believe that Mr. Carson has ownership of a white van?
I have seen him putting 2 dogs in that van on May 1st. About 5 minutes before our agreed upon appointment, where Sandy, David Bristol, and myself toured the property and spoke with both tenants.
So whether he owned it or not, he certainly had access to it.
He had keys that unlocked, and he opened the door and put 2 dogs in.
No further questions.
Did you say you had video, or is this what you're talking about?
The video, Your Honor, was taken by another witness who is out of the state at the moment. So if we do come back, I can present that, Your Honor, and have her testify.
Okay, sounds good. I'm going to give you this evidence back for now. You had an issue about the property. You wanted an order?
Thank you, Your Honor. I'd like an order for immediate possession and reserve the money judgment for a continued date.
Well, order for possession is granted. They said they've already turned over possession
That's never been
of
a
the
question.
property. We'll deal with the money judgment. We'll continue for the money judgment issue.
Right.
Obviously, if they have to clean up trash and debris, that goes towards their money judgment claim. You do understand that, correct?
What's that?
If they have to go into the property to clear out the trash and debris, that costs money. And so that's also evidence that will go towards the money judgment. You
And
understand
now, I don't know if it's possible or anything, but I would have had no problem communicating that with her, that I would be willing to take care of those items and get the property up.
No, you just told me earlier that you had no choice.
So I didn't have the means that within 7 days, but then I can say
No,
I
but
can come back with a truck
It's
when I can afford
it's
it.
been 6 months since
Yeah,
you said you left.
Yeah, and I just assumed they wrote it all off. That's why we're here today.
You could know as soon that they
And
filed
I
an eviction.
also, go ahead.
They've been on notice of this for several months, Your Honor.
You couldn't have assumed there's been an eviction pending, so you knew that the
And
eviction was still
Is it
pending.
general practice for them to drill out the locks and give themselves back the property without a judgment from the court?
It's not general
Okay,
course,
'cause that has
however,
happened.
it's also not general course of legal property. That's why I asked, was the property secured and was it winterized? Because if you vacated a property, if I take what you say to be truthful, that you vacated a property in May and that you called one time, no one answered, you left no voicemail, you never followed, do not talk while I'm talking. You left no voicemail, you never followed up, you never got any word to make sure they knew that the property was vacant. That means you left the property exposed and any animal, creature, person could come and take over this unit because you just left it abandoned with things there. When you leave things there, they don't know off the top that you have moved or rendered possession unless you notify them. This is if I'm taking what you say to be true. And then on top of that, there's still electricity going to this. So if they check the electricity, they see that's still going on. So there's no reason for them to believe that you vacated unless you have communicated to them that you have vacated. It is now the dead of winter. We're in the middle of a snowstorm. It's going to be 0 degrees. That's why I asked, was the property winterized? Because if it wasn't winterized and those pipes freeze and burst and there's damage to the property, and I make a ruling that you have not properly turned over the possession, then now you're responsible for the damage if pipes freeze too. Do you understand how that works? Okay, so what is it that you feel like so urgent that you need to share with me?
I was just wondering, am I the only one that's responsible for communication? If they had any questions, they couldn't have reached out at any point during this? Do they have any attempts to reach out to me or any of my people
No,
to resolve it?
They did reach out to
Other
you.
than court?
They filed a notice to quit and vacate, and then they filed a summons and complaint to bring you to court. They have communicated.
So-
If you have vacated the property, your responsibility is to let them know that you have vacated and turn over the key.
Should they choose not to accept my calls?
You didn't, you testified 1 call. That was your testimony.
Yes, I'm aware.
I already have enough for possession. You didn't turn over.
I'm not questioning.
Yeah, you
possession.
didn't
I'm
turn
just saying they
over,
took it
you
without
did
me
not
saying
turn
so.
over possession reasonably. It's not,
I just was
that's
under
not
the impression they
reasonable.
took it unlawfully.
Well, you left,
There was never a judgment for them to go in and drill out the locks
you
and
mean,
give them
what,
access.
when did they do that?
I have no idea.
So how do you know they did that?
Because I went there after our last court date when I was realized that they thought we were still there.
After the last court date when you told me you had vacated in May?
Yes, I vacated in May.
So you're saying in May they drilled out the property and
I
changed the
have
locks?
I have no idea what their time frame for lock drilling was. I
No.
know in November when
You
I
went in
went there,
November.
the locks were drilled out.
After you've already communicated
when
that
I
you had,
found out that they thought
after
we
you
weren't
had
there.
already communicated that you didn't live there?
Yes. Because
So then
at
what's the
that
issue?
point, they thought the property was still mine.
No,
As
at that
far as
point,
I'm
it's the middle of the winter
They're
and you
still
claim you
charging
left.
me for it.
In the middle of the winter, you claim that you left and you left all your stuff
No, I
there.
didn't claim.
And you said
I
that
left
it's not
in
your
the winter. I told
responsibility
you
to get it
May,
out.
Not the winter.
Judgment for the plaintiff
For possession or money?
and money.
Thank you, Your Honor. Can I include standard cost in that?
Absolutely.
Thank you, Your Honor.
Thank
I'll
you.
get that submitted on e-filing.
Can I object? I mean, can I
You
like?
can object all you want. I'm done. Thank you.
We weren't even there. Like, they're getting this.
Do you want me to have you escorted out?
Oh, actually.
Excuse me? You want contempt next? Because I can give you 93 days in jail. Sparrow Properties versus Sandy Property Management. Like Chase Carlson and Amanda Williams, 24-07290. Counsel, can I have your appearance?
Good morning, Your Honor. Jessica Larson appearing on behalf of the plaintiff.
Is this Amanda Williams?
It is.
Okay, and Mr. Carson, you can remove your hat. This is the court proceeding. Okay. Today was the date scheduled for a discovery or a debtor's examination. Were you able to complete your exam?
No, Your Honor. Mr. Carson refused to answer any of my questions. He said he's not going to play games with me.
What games are being played, Mr. Carson?
Well, Your Honor, when I was previously there, I received a verdict by you that I believe to be emotionally charged due to your frustration with my inability to complete the tasks of a lawyer. I attempted to get a lawyer through the system. They denied me. I had to show up last minute unprepared, and things didn't go my way. So I figured, I'll do the process. I'll try to appeal it. I go downstairs and I'm told I have to pay $200 and some to even have a chance to get a fair trial or verdict. I'm having one individual who was emotionally charged at the time decide what has to happen with me instead of a jury of my peers. And now I'm being told I have to produce all my financial statements, documents, vehicles, titles, all this. And I have no interest, time, or energy to continue this charade. I've lost several days of labor.
Let me stop you because I'm just getting updated on this case. This was a landlord-tenant hearing that I presided over. Did you demand a jury trial?
I'm sorry?
Did you make a demand for jury trial in the landlord-tenant?
I requested, yes.
You made was there a demand on
In written, I didn't put anything in writing. I did request the trial. I went downstairs and asked what my rights are, and they said to proceed any further past your decision, I had to pay $200 and some to even try. Did not have the money at the time, nor would I have it.
But sir, I asked you to let me get caught up. I'm trying to see if you have filed a jury demand. Let me also be clear. I don't make decisions because I'm emotionally charged.
You.
No, don't talk over me. Don't talk over me. Just because I won't let you run my courtroom does not mean that I am emotionally charged. There's order that will be set in the courtroom and you will not talk over people. You will present the evidence. I'm absolutely fair and impartial, and you then have the right to appeal my decision. Just because you disagree with the decision doesn't make it impartial, okay? And if you don't follow, there's rules in place that I don't set as to how you file such appeal. If the clerk's office told you what you needed to file to move forward with the appeal, then that's what you needed to do. But I'm going to make it clear on my record that I don't make, and I did not make a decision in this case based on any emotions. I have no reason to be emotional about your eviction, sir. I'm not being evicted. So if you keep talking over me, this is probably what you did the last time. It's try to cut me off. Yeah, and you're shaking your head. So that's not me being emotionally charged. That's me not allowing you to run my courtroom. You don't talk over people. You have a question.
Yes, I was just speaking and you cut me off, but I'll let I
run the courtroom.
Okay, I understand.
Did you notice that?
May I finish, Your Honor, please?
Yes.
Okay. At the time of the last proceeding, I interrupted you. I apologize. But the second or third interruption, you stopped me in the middle of my sentence and awarded them the decision. You know what? You were like, you know what? Decision for them. You didn't specify why. It was just an emotionally charged because you were frustrated with my inability to complete the tasks of a paid lawyer.
I have evictions every single week, and the majority of my evictions are people who do not have attorneys. I don't know if you know that. Over 75% of our cases do not have attorneys representing them. I do not get frustrated with your inability to do the task of a lawyer. Where I will get frustrated and where I will not tolerate is if you think you're going to yell out or yell at the other party, yell at me, and you're going to act a fool in the courtroom, I will no longer allow you to be heard. Just because I cut you off and make a ruling does not mean that I ruled in their favor because I was frustrated with you. I was going to rule in their favor anyways because of the facts of the case. I was allowing you an opportunity to be heard. But when your opportunity to be heard becomes a hindrance to the procedure in the courtroom, then I have to terminate the hearing. And so if you want to proceed in any other manner, I don't know what your rights are now at this point as it relates to your right to appeal. You may have exhausted that time frame, but you're going to need to appear in person. I'm going to reset this since you refuse to comply with the court order to participate with the discovery proceeding. Because this is an official proceeding. This is not your option. You have to participate in the proceeding because you have a judgment against you and the plaintiff has the right to figure out how they can recover on that judgment.
Can we
Do you understand that? Yes, you may.
Well, we tried to tell her, the funds, we can pay them. We have no problem with that. We tried to tell her the same thing.
What is the past due amount?
It's roughly somewhere in the ballpark of $10,000 with interest, Your Honor.
I
asked him if they could make a payment in full, and he wanted to argue the merits of the judgment itself.
Okay.
I never heard an indication there would be a payment in full. If there's some sort of payment plan, I'm happy to discuss that once I get my questions answered, because they have made no efforts to make payment on this, never reached out. We've tried multiple different avenues for the information that we did have on where we thought they banked and where we thought they worked. So I would need answers to all of the debtor's exam questions, and then I'm happy to work out a payment plan. In the event of a default, then I can pursue other arrangements.
Okay. Are you in a position to pay in full the past due amount?
I'd prefer a payment plan. And I would like to see what the interest is and what the original charges are. I was never actually formally presented with any numbers, despite what she had just told you. Until we were physically served for this court date, I had heard nothing other than a couple of emails where they were denied requests to garnish.
Yeah, we haven't received.
That is literally the only thing pertaining to the case I've seen since I walked out of your courtroom, attempted to file for an appeal, and was told I had to physically come up with money to do so that I didn't have at the time. So I at no point was ever given a fair trial. I was given an opportunity to pay for one potentially. But I've received, the judgment is for, you gave them and rewarded them things they shouldn't have had. We weren't there.
If you disagree with the court's position, you have the right to appeal. You failed to do that. I also want to correct the record again. You did not properly file any demand for jury trial, although being advised on your first appearance of how you have the right to a trial and how to file such jury trial demand. You did not file a jury trial demand. So if you didn't get a trial, that was on you.
Then I guess I misunderstood. That goes back to me not being a lawyer and wishing that I had.
That does not go back to you being a lawyer. We made a video. We make a virtual presentation. It's a video that I play, and every courtroom in this court plays that video at the first appearance. Most of you all don't pay attention to the video. It tells you very clearly in very plain language. You have the right to a jury trial. And you can make such demand for a jury trial, and it tells you how to do that. You don't need to be an attorney to do that.
Sorry, go ahead.
I'm done.
Can she produce an actual number, or are we going off of what she thinks?
So I'm asking for what's in the judgment plus whatever interest is, and I haven't calculated it.
You wouldn't have calculated that before today?
You can do one of two things, sir, because I'm not gonna, the games that are being played, I do not believe are on the part of the plaintiff at this point. You can participate in good faith right now in the debtor's examination, provide the answers to the questions, which are under subpoena. You've been ordered to court for this purpose. Or I can reset this and order you to appear in person. If you fail to do that and to comply, then we have to proceed to a next step, which is a bench warrant. And I don't think you want a bench warrant over a civil matter. So it's in your best interest to comply. It sounds like she's willing to work with an installment payment order, but only after she gets the answers that she needs to figure out how they're going to recover on this debt. So how do you want to proceed?
I'm sorry, Your Honor.
I'm sorry.
I asked him if he had any of the documents there were, in addition to information, the documents, plenty of documents that were asked for, and he indicated that he wasn't going to produce those. So I would ask him to appear in person with all of the documents.
Oh.
And I'd also ask that, Your Honor, that he return to a tone that is respectful. He has screamed expletives at me the last time we were here in court, and he's called me things today. And it's uncalled for and unnecessary.
I am absolutely clear that the emotional charging was not from the courtroom. I'm not going to allow you to berate anyone in this courtroom, nor will you disrespect me or the process. You can appear in person. I'm going to reset this date, and you need to bring the documents that were ordered under the subpoena. If you fail to comply, the court will issue a bench warrant.
Your Honor, save yourself the time. Have her fax.
Don't tell me what to do. Don't tell me what to say.
Or
you instruct yourself.
I'll pay her
You instruct yourself. You instruct yourself, or you'll be in contempt of court. Okay?
Excuse me?
You control your own mouth. Don't tell me what to say. I've already given you an opportunity. I'm now resetting this. You can appear in person. If you pay in full, then they can move forward to make sure that this removes off of my docket. But do not tell me what to do. I do not tolerate your tone. This is how we got here the last time. That might work with the lady. That might work with the lady sitting next to you. But you don't talk to me like that. Not in the court, not outside the court. Do you understand that?
I'll pay the balance.
Thank you.
My phone number is on all of the court paperwork. You can give me a call and I'll give you a number.